And it's important, Sarah, because what he said to the police, they're going to argue, prosecutors, that it corroborates his involvement and it corroborates his guilt. And as you noted at the outset, they didn't say he pulled the trigger, but you don't have to establish that, just that you aided, you abetted, you counseled, you encouraged, and that's what they're saying he did here.
And look, the other people who were under suspicion by police, one of whom was his relative, have all passed away. He is the only person sort of left in this scenario who's accused of being there that day and taking part in all this. I do want to ask you about the bigness of this case, because he is not wrong that this is one of the biggest cases ever in Las Vegas, because of who was killed and because of all of the rumors around who was responsible. There was this big feud going on between East and West Coast rappers, and that has just taken on a life of its own. Finding these 12 jurors, especially if they're of a certain age, they would know about this case. How difficult do you think that will be?
So always challenging, but certainly mechanisms in place for that. And what are those mechanisms? Remember, Sarah, that you can challenge what they'll probably get. I'm thinking you need 12 jurors, of course, to sit in the box, but they'll likely get between 4 and 6 alternates in case someone gets sick. So when you're picking a jury, what happens is you're asking them questions. Do you know about the case? Do you have any opinions about the case? Do you know who Tupac was? Did you really admire him as a rapper? Do you think someone should be held accountable, even if the evidence doesn't establish it? You're going to ask all those questions. But when you're actually picking a jury, if a juror says they're biased, you can excuse them. It's called excusing for cause, and that's unlimited. But then there are these other challenges called peremptory challenges, in the weeds a little bit, but each side gets 8 of those, and you could excuse someone for any reason or no reason, as long as it's not predicated upon some type of racial reason, et cetera, for which you're excusing them. And so therefore, yes, of course, it'll be a challenge. I think they could get it done, because the main question is, even if you heard about the case, can you base a decision on the facts and the evidence or the circumstances in the courtroom, not what you read in the paper or saw anywhere else? So it's on, and it starts today.
Lastly, this happened almost 30 years ago. How difficult is it to bring a case like this, with the idea that there is a book out there published by the person on trial, and there's a lot of comments, which a lot of people say, well, that's the reason why this has happened in the first place, because Duane KVD kept talking about it.
Yeah, so I think it's very challenging, right? I know we're in a day and age, certainly, where there are cold cases, and that's why there's no statute of limitations on murder. You could bring it 10 years, 20 years, 30 years, like here, or even more. And I think from a defense perspective, they're going to argue you don't have a weapon, you don't have the car, ballistics wasn't done on that, there's no forensics, there's no DNA, there are no living witnesses.
Langsmith engine has been quite helpful in streamlining the enormous amount of traces that we'd otherwise have to look at manually. And so aggregating these traces together and then extracting insight from it is really valuable, and especially with the context of the source code of the agent itself, in addition to obviously all the actual traces and all of the evals that were run. So kind of merging these 3 data sets together with an intelligence layer gives us incredibly valuable insight and could produce really good work, like all the way to opening PRs and fixing things at the root with all the right information in full view. We have team members that are not as familiar with the, say, agent engineering part of our stack, be able to use engine to actually diagnose issues and then open PRs themselves, even though they're not like the person that has been handcrafting it since the.
Prosecutors say some of their strongest evidence may be his own words. They argue that Davis implicated himself through his memoir and by discussing the events of that night in media interviews. Back in 2009, Davis told police he had a role in Tupac's killing, but he wasn't charged because that interview was part of a deal preventing his statements from being used against him. Prosecutors say that protection no longer applies, since Davis later repeated many of those statements publicly. Death Row Records executive Marion Suge Knight and Sean Diddy Combs are both potential witnesses for the prosecution. Tupac's killing has remained one of the most high-profile unsolved mysteries for decades. Opening statements are expected to begin next week.
Jury selection will resume Tuesday on the murder trial of Duane Davis, the man accused of killing rapper Tupac Shakur nearly 30 years ago. Davis is the first and only person ever charged in the rapper's fatal shooting. He has pleaded not guilty. Tupac's killing has remained one of the most high-profile unsolved mysteries for decades. But prosecutors say Davis's own words may be just the evidence they need to prove him guilty. CNN's Nick Watt reports.
Hey, Keith, Metro Police, come over here.
Keefe D was arrested 3 years ago.
So what they got you for, man?
Biggest case in Las Vegas history.
Oh, yeah?
The shooting, the killing of Tupac Shakur at a stoplight in Vegas late one night after a Mike Tyson fight nearly 30 years ago. Here's what prosecutors will argue, detailed by a homicide detective just after Duane Davis, Keefe D's, arrest.
As we all know, Tupac Shakur was an artist who was signed with Death Row Records. And that Death Row Records and its CEO, Marion Suge Knight, were closely affiliated with the Mob Piru criminal street gangs, and that they had an ongoing feud with the Southside Compton Crips. Duane Davis was the leader and shot caller of the Southside Compton Crips.
Members of both gangs were, say police, at the Tyson fight in the MGM Grand that night, and afterwards, in the lobby, Tupac, Knight, and others spotted Keefe D's nephew, Orlando Anderson, and beat him up.
Duane Davis began to devise a plan to obtain a firearm and retaliate against Suge Knight and Mr. Shakur.
Anderson, his uncle Keefe D, and two other men allegedly got into a white Cadillac and followed Knight and Tupac, who were in a black BMW en route to a club. Unclear exactly who pulled the trigger. Some have said it was Anderson. Keefe D is the only man who was in that white Cadillac who is still alive. He's now 63. He was, they say, the shot caller, and under Nevada law, he can still be charged with murder.
Within the first few months of the investigation, our detectives knew most of the information I just briefed you on. However, we never had the necessary evidence to bring this case forward.
His own words, say investigators, were Keefe D's undoing.
Specifically, Duane Davis's own admissions to his involvement in this homicide investigation that he provided to numerous different media outlets.
Them jumping on my nephew gave us the ultimate green light to do something to their And in the documentary Murder Rap, Inside the Biggie and Tupac Murders, Keefe D describes the moment he says he handed Anderson, whom he calls Lane, a gun while riding in that Cadillac.
I gave it to Dre, and Dre was like, no. And Lane's like, dude, Papa, too.
But in July, Keefe D denied being involved in the killing, telling a Las Vegas news station he wasn't even in Nevada when Tupac was shot.
I ain't worried about I ain't getting so.
Well, I mean, that's what court's for, right?
Latest we hear from court, they have seated now 7 jurors. Jury selection is what's going on right now. They need to seat 12 plus 4 alternates. The actual trial itself, we're told, could take 4 or 5 weeks. Now, during the jury selection, it's been clear that the defense is going to lean heavily on the fact that there might not be that much physical or forensic evidence left after 30 years. They're pointing out that, remember, people didn't have cell phones back in those days filming everything. There weren't the surveillance cameras. The defense really trying to paint this as a potentially uphill battle for the prosecution to finally convict somebody of Tupac Shakur's murder. Nick Watt, CNN, Los Angeles.
Happening now, after nearly 30 years, the trial is officially underway for the man accused of orchestrating the 1996 murder of rap legend Tupac Shakur. Authorities arrested Duane Keefe D. Davis back in 2023, charging him with 1 count of first-degree murder. Prosecutors say much of the evidence they gathered against Davis is based on his own words. That includes a 2019 tell-all book in which prosecutors allege that Davis laid out his role in the fatal shooting. Shakur was shot during a drive-by after leaving a boxing match on the Las Vegas Strip. After 6 days on life support, he was pronounced dead. Prosecutors say that Davis arranged the shooting, which also wounded Death Row Records CEO Suge Knight, who was in the car. CNN is learning that Suge Knight is among the potential witnesses in this case, as well as Sean Diddy Combs, who could be called to testify. Let's bring in CNN legal analyst and former prosecutor Joey Jackson. Joey, great to see you as always. First, as we talk about jury selection, talk to us about what both sides are looking for in jurors, noting that the judge granted only partial sequestration for this upcoming jury.
Yeah, Bars, good to be with you. And so the essence of any jury is that they could be fair and impartial. We know that this is a murder case. No, prosecutors are not suggesting or saying that he pulled, that is Keefe D. Mr. Davis pulled the actual trigger, but under what's called accomplice liability. If you're aiding, abetting, counseling, encouraging, then you're equally as guilty. But before you get down to the factual determinations as to whether or not he intended and engaged in premeditation with regard to this murder, and there's also a gang enhancement to the extent that they're alleging prosecutors that he was involved in a gang at the time, the Crips. What you have to get down to is whether you can select a jury who can hear and be receptive to this evidence. And so the essence of it is jurors will be weeded out by making the determination as to first scheduling. Are they available to do the case? Do they have any hardships that might keep them away from the case? And then you get to the core issues of, hey, what do you think about celebrity and what do you think about fame? And by the way, have you read the book that Mr. Davis has put out on this particular issue? Have you listened to any podcasts? Have you listened to anything else with respect to what may be in the public domain? And if you have you formalized any opinions that would not make you an effective juror? Last point on that issue. In the event jurors say, hey, I can't be fair, I can't be impartial, I love Tupac, whoever did it, I think he did, should be held accountable, then you're excused for cause. When that happens, Boris, anyone can be excused for cause if they exhibit that type of bias, and you could do that all day and all night. They're unlimited. And then you get down to after the for cause challenges, which they just can't sit, each side has 8 peremptory challenges in which you can excuse jurors for any basis whatsoever, as long as it's not predicated upon some racial exclusionary ground. And that's how this will unfold as they ultimately try to, prosecutors in the defense with the court, select.